my name is Amy. I'm a second-year law student, like Rory, at Berkeley Law. And I'd like to preface this presentation by saying that I love cats a normal amount, and this presentation should not be interpreted otherwise. It's a lie, I love cats. Hey. Which button? So, the founders of the Greek Commonwealth are confused, and rightly so. Employment law is very confusing. In my section, I will be talking about whether and how employment law impacts co-ops. Specifically, I'll be covering the key differences between the traditional employment model and the cooperative model, how employment laws can be problematic for co-ops, the four major legal categories of how members of a co-op could escape the definition of an employee, and how co-ops can sometimes take advantage of these certain exceptions to avoid strict employment law requirements. So, we're all familiar with the traditional employment model. In legalese, it's something that we call the master-servant relationship. As the term indicates, the employer controls the work and also benefits from the profits generated by the workers. As we know, this can be a dangerous combination because the employer might sacrifice the welfare of the workers, the environment, pretty much anything to maximize its profit. Compare this to the cooperative model, where, as we've discussed, the workers democratically control what they do and share in the profits together. So, given that the workers in a co-op exercise a lot of control over their own work and also share in the profits, surely they don't need the same protections as a worker in a traditional master-servant relationship, right? So by a show of hands, how many of you think it is true that a co-op do not have to worry about employment laws? Wow, y'all are too smart. How many of you think this statement is false? All right, you're a smart crowd. So, those employment issues for co-ops can be quite complicated, and co-ops do have to worry about employment laws. Y'all already knew that. Why? Because employment laws were designed to cover as many people as possible so that no workers would be left unprotected by some loophole. So employment laws even cover collaborative, democratic, participatory, self-sufficient, and accountable economies that are created in a cooperative relationship. So it's a little ironic because the current employment laws still haven't really led to a balanced employer-worker relationship, and the law contribute to another kind of social economic balance. So while the laws are designed to protect employees, they also force some people to become and remain employees by making it prohibitive for them to operate a small business, like a cooperative. Okay, so what should co-ops like the Green Commonwealth do? Co-ops should start with the assumption that everyone is an employee and then work backwards to find an exception that they might qualify for. But before we jump into what these exceptions are, let's think about why worker owners do not want to be considered employees. So, if a co-op has employees, what are some of the obligations that the co-op would have to comply with under current employment laws? Just shout them out. There's a hint, by the way. Go ahead. Minimum wage. There you go. Very good. Minimum wage. Workers' comp. Workers' comp. Very good.
Child labor laws.
Very good. Yes.
Overtime.
Yes, very good.
Breaks.
I'm sorry?
Breaks.
Breaks. Very good. Okay, so those are all correct. So, we said workers' comp. So workers' comp is insurance, and you have to have it even if you have only one employee. It serves to provide medical and disability benefits if an employee gets hurt on the job. In general, it costs about 10 to 20% of the wages you are paying your employees. We said minimum wage and overtime. Does anyone know what the current minimum wage is in California?
$8.50.
I think it's 8 and it's going up in June. But in San Francisco? 10. 74. Close enough. We said payroll taxes and withholdings, so co-ops would have to withhold money from each employee's paychecks for federal and state income taxes, Social Security, Medicare tax, and unemployment tax. The Green Commonwealth would have to provide safe working conditions and comply with safety standards. That would also mean having to comply with the Occupational Safety and Health Act, OSHA. This would also include posting notices, performing tests, keeping records, I've got fancy with the animation, and other requirements designed to protect employees, but that can also get pretty costly, especially for a co-op that's trying to raise money. Finally, we have that. There you go. You have to verify an employee's eligibility to work in the U.S., and this can be very problematic for organizations that are interested in having cooperatives for undocumented people who may not be eligible to work in the U.S. as employees. But undocumented people are not prohibited from owning a business in the United States. Therefore, if the Green Commonwealth would like to have worker owners who don't necessarily have a work authorized legal status, then the Green Commonwealth would need to make sure that they are not classified as employees of the business. Finally, these can all be very expensive, like we said. So, now what do the process? Now we'll outline the four ways a worker owner could be classified as something other than an employee. And the four ways that people can work together and not be employees are partners, people that work together for their mutual benefit; volunteers, people that do unpaid work for public benefit; interns/trainees, people that do unpaid work for their own educational benefit; and independent contractors, people that do work but do so in an independent manner. Next, we're going to highlight some main factors. We are going to try and utilize some of these exceptions. So partners, the main premise is that a partnership is that if there is no master-servant relationship, then employment laws don't apply. And there is no master-servant relationship if all the workers work for their own mutual benefit, The thing to note here is that if you would like to argue that members of your worker cooperative are not employees, then the safest things to do are these four things: have all of the members serve on the board of the directors, make decisions by a consensus process or with a supermajority vote. Arguably, this gives each member a strong voice in each decision. Give each member a lot of control over their own work, or create many semi-autonomous departments or committees that control their own work. And make it somewhat difficult to fire people by requiring a vote of a large number of members. All of this information, by the way, is in your manual on page 47 to 51. Next, we have volunteers. Volunteers donate their services without expecting payment for their work, and they are not considered an employee. Therefore, the employment laws don't apply. So if you're a nonprofit with a charitable, religious, or humanitarian purpose, you can have volunteers, but unfortunately, most co-ops do not fit under this 501c3 category of nonprofits. And having volunteers for a for-profit business could result in liability for violating employment laws. But you can have interns who work for their own educational benefit. Hooray, that's awesome. Caveat though, interns must be there to learn. So if your co-op would like to have interns, one way to do that is to create a training program that meets specific requirements. There are several criteria that determine whether your internship will be considered a valid internship, and they are listed in pages 61 to 63 in your manual. Essentially, the focus of your internship program should be education. Finally, another way to be free of employment law is to be an independent contractor. As we said, an independent contractor works in an independent manner, but the test for who qualifies as an independent contractor varies across the jurisdictions. There are several factors that go into deciding whether you are an independent contractor or an employee, such as, there's going to be a lot of words on the next slide. Oh, there are already. Who controls the manner of means by which the practice is accomplished? For example, if the Green Commonwealth controlled how the landscaping is to be done by each worker, then that would weigh towards defining the founders as employees. The skill required, if the work required a high level of expertise, like a sculptor, for example, then this would weigh towards finding an independent contractor relationship instead. As you can see, there are many more factors that go into this analysis and that would weigh into this decision. They all listed on pages 63 to 64 in your manual, so you don't need to know all of these right now, but the key takeaway is that the court will look at the behavior and not what you call them, so that's what that was for. And you can see determining who is an independent contractor as opposed to an employee can be a tricky test, and you should be aware of these factors. So, enough of my lecturing. I'd just like to do a brief exercise with you and help you see how some of these issues can unfold. So let's say our founders decided to create an urban farm, yet again, with 30 new members, and the goals of the urban farm were to provide access to fresh produce to the local community, but also to earn a livelihood. All members are required to spend 3 hours per week volunteering on the farm to get cheap produce. Each member spends time irrigating the farm, tilling the beds, and harvesting, and also handling some administrative tasks. Each 3-hour shift has a supervisor that manages the members doing the volunteer shifts. A show of hands, who thinks Green Commonwealth is in compliance with employment laws. Who thinks they're not? Very good. So we're going to outline why. No. It's possible that the members of this situation should be paid minimum wage and that all other regulations on employers and employees apply. They're not volunteers because the urban farm does not clearly serve a public benefit. The members are not independent contractors because they don't really control the matter means of the product, and the work doesn't really require a whole lot of skill, and they are managed by a supervisor. The members are not likely partners because most members have no decision-making authority over the day-to-day operation of the co-op or even their own work. And they are not interns because they're not really doing it for the purpose of learning a skill. So that's crazy. But there's no. The Green Commonwealth founders have so many resources here in the Bay Area, and they should consult these excellent legal services for advice. Now that the founders don't know where to get employment law advice, let's see what's on their mind next.